Greetings. Today we're going to cover the scopes of Article 9, basic terminology and basic concepts. The operative statutes governing liens in personal property is Article 9 of the Uniform Commercial Code, otherwise identified as the UCC. Article 9 applies to tangible, quasi-tangible, and intangible personal property, from equipment and inventory to promissory notes and electronic chattel paper. Article 9 has its origins in the Industrial Revolution. Before the Industrial Revolution, one could not pledge personal property as collateral. Pledging personal property was even a crime. With the Industrial Revolution, it became apparent industry required more alternatives for financing. Various forms of personal property liens, such as the pledge and the chattel mortgage, developed, originally proposed by the drafters in 1952, and now adopted by all states and the District of Columbia in some form. Article 9 of the UCC brought uniformity to the patchwork of common law personal property lien laws, substantially revised several times since its original enactment. Article 9 seeks to facilitate financial transactions by fostering predictability. Article 9 endeavors to simplify the law, create transparency, and remove impediments to initial secured financing as well as secondary markets and securitization. Article 9 includes a few types of personal property and transactions one might not expect to be governed by Article 9. Some of the more unusual categories of personal property include and excluded from Article 9 are listed below. Personal property includes, under Article 9, assignments for the benefits of creditors, a security interest, and the initial assignment for the benefit of creditors, along with subsequent transfers by the transferee, UCC subsection 9-309-12. Consignments. Most consignments are now treated under Article 9 like a purchase money security interest, PMSI, which will be discussed more fully below. UCC 9, subsection 9-109A4. There are still, however, three categories of consignments exempt from Article 9. Consumer goods consigned to a merchant, consignments totaling under $1,000 each, and goods delivered to merchants, generally known by its creditors to be substantially engaged in selling the goods of others. Tips. As discussed more fully below, while true consignments do not require a written security agreement under Article 9, they do require the filing of financing statements. Because it is often difficult to determine with certainty whether a transaction will be deemed a true consignment, it is advisable that the practitioner, out of an abundance of caution, comply with the security agreement and filing. The liens are deemed perfected upon attachment without filing. See UCC subsection 9-309-12, CMT 8. Security interest includes any interest of a cosigner, UCC subsection 1-201B35, pursuant to UCC subsection 9-102-20. Consignment means a transaction, regardless of its form, in which a person delivers goods to a merchant for the purpose of a sale. Note that a sale need not be exclusive reason for the delivery of the goods. UCC subsection 9-102 CMT 14, see Georgetown Steel Company, LLC versus Progress Rail Service Corp. in regards to Georgetown Steel Co. LLC 318 BR 352-358, Banker DSC 2004. Iron was delivered for sale, although merchant proceeds the iron into steel prior to sale. Merchants process the iron into steel prior to sale. But if the collateral was only delivered to the seller for storage, there is no consignment, only a bailment, and Article 9 does not apply. In regards to Green Line Equipment 390 BR 576, Banker ND Miss 2008, consignments are often inventory under Article 9, and thus a secured party must be sure not only to file a financing statement, but also to comply with the inventory special timing and notice provisions. In regards to Slanders O'Reilly Galleries LLC 506 BR 600, Banker SDNY 2014, see UCC subsection 9102A20, a creditor's actual knowledge that the co-signee is substantially engaged in selling the goods of others is usually sufficient for a court to subordinate the creditor's interest. In regards to Fariba versus Dealer Service Corp. 100 Cal RPTR 3D 219 221 70 UCC Rep Serve 2D 193 200 through 203 Cal CT APP 2009. See also Bailmont Intel Inc. versus AM Intel Shoe Co. 831P.2D15 or 1992. 3A David Fisher Anderson on the Uniform Commercial Code subsection 2-327 full colon 94 3D edition 2019. Requirements of Article 9. Article 9 expressly provides that filing a UCC1 is not an admission that a transaction is not a consignment. Commercial tort claims. A limited category of commercial tort claims falls under Article 9. This category includes only business claims arising in tort. It does not include claims for damages arising out of personal injury or death, UCC subsection 9-10213. Healthcare insurance receivables. Claims under an insurance policy are generally excluded from Article 9, except to the extent they are proceeds of other collateral. Healthcare insurance receivables are exceptions, UCC subsection 9-109 D8, 9-1022, and 9-10246. Letter of credit rights. Article 9 applies to the right to payment and performance under a letter of credit. Article 9, however, specifically excludes the right of beneficiary to demand payment or performance under a letter of credit. This subject is governed by Article 5 of the UCC. Non-promissory statutory agricultural liens, as discussed more fully below, Article 9 is generally limited to consensual liens and excludes involuntary statutory liens such as garage keepers and landlord liens. See UCC subsection 9505B. Commercial tort claims may not be the subject of an after-acquired clause, but may be proceeds of other collateral. UCC subsection 9204B2, 9102A, 64, and 9-203F, and 9-315. A breach of contract claim is likely to constitute proceeds of accounts or a general intangible. See Sams versus Redevelopment Authority of City of New Kensington, 261 A2D 566 7 UCC Rep 336 PA 1970. The payment obligation under the settlement of a lawsuit, even a personal injury suit, is a payment intangible. UCC 9, subsection 9-109, CMT 15. There are virtually no defense to letters of credit, making these instruments generally preferable to guarantees and sureties. See UCC subsection 9102. A51. There are actually three sources of law governing letters of credit. 1, the UCC Article 5. 2, Uniform Customs and Practices for Documentary Credits, UCP, revised in 1993 and reissued as ICC Publications number 500. And 3, the International Standby Practices, ISP 98. The UCP and ISP 98 are not laws, but rather rules incorporated into letters of credit by the parties. The UCC covers letters of credit issued by banks and others under the UCC. A letter of credit is irrevocable unless it provides otherwise. UCC subsection 5106A under the UCP and ISP 98, all letters of credit are irrevocable. UCP Art 2 and 3, ISPA 98, Rule 1.06. Article 9 does, however, apply to non-promissory statutorial agricultural liens, UCC 9-109A2. Public financing transactions, government-created security interests are included within Article 9, unless specifically preempted by a state statute that governs creation, perfection, priority, and prosecution of the security interest, UCC 9-109C2. Sales of accounts, chattel paper, payments, intangibles, or promissory notes. This aspect of Article 9 is counterintuitive. Article 9 is not limited to a pledge of accounts, chattel paper, payment, intangibles, or promissory notes as collateral, but also includes an outright purchase and sale of these types of collateral. You'll find that in UCC subsection 9-109A3. Note, payment intangibles and promissory notes are subcategories of general intangibles and instruments. Respectively, Article 9 does not apply to sales of general intangibles other than payment intangibles. These sales are governed by common law. Article 9 does not apply to sales of instruments other than promissory notes. These sales are governed by Article 3 and the common law. Security interest arising under Articles 2, 2A, 4, and 5 of the UCC, and Article 2, sales securities interest arising under UCC 2-401, when a security interest is created by a sale subject to a reservation of title. Security interests include a buyer of accounts, chattel paper, a payment, intangible, or a promissory note in a transaction that is subject to Article 9, UCC, subsection 1-201, B35. It is often not clear whether a transaction is a true sale or a sale intended as security, especially where there is any form of recourse. See Citizen Bank and Trust Co. versus Security First Inc. Holdings, LLC. In regards, Brookie Capital Corporation, 588, Fed Apex, 834-85 UCC Rep Serve 2D 348, 10th Circuit, 2014, participation interest, not a true sale. In regards to commercial money, CTR, Inc., 350 BR 465 BAP 9th Circuit 2006, this sale versus loan issue often turns on the nature and extent of recourse of the buyer to the seller, especially since the parties' characterization of the transaction generally does not govern UCC subsection 1-203. Texas and Louisiana adopted non-uniform provisions of the UCC which provide that the parties' characterization governs. Article 9 makes clear, however, the facts that a buyer may have some level of recourse does not preclude a true sale. See UCC subsection 9607, CMT 9, which in addressing whether a buyer secured party must act in a commercially reasonable fashion in foreclosing an interest in accounts, chattel paper, payment intangibles, or promissory notes, provides that the buyer secured party must meet the commercial reasonableness standards. If there is recourse, even though the assignment to the secured party was a true sale, the difference between a sale and a loan can be significant for purposes of usury, accounting, tax, bankruptcy, and perfection. An Article 2 sale security interest granted under UCC 2-711(3) to an aggrieved buyer upon rejection of goods, and Article 2A, lease security interest granted under UCC subsection 2A 508(5) to an aggrieved lessee upon rejection of goods, and Article 4, security interest of a collecting bank under UCC subsection 4 to 10, and an Article 5, security interest granted under UCC subsection 5 118 to an issuer or nominated person in a letter of credit and proceeds. Software is subcategory of general intangibles, UCC subsection 910242. Supporting obligations, guarantees, letters of credit, and other supporting obligations of a debt, i.e. chattel paper or promissory notes, are generally automatically included when the debt is pledged. See UCC subsection 9203, 9308D. Personal property excluded from Article 9. Despite its breadth, there are many personal property liens excluded from Article 9, at least in part. Additionally, in certain cases, Article 9 defers to specific state and or federal law for perfection and priority issue, but may still apply in whole or in part to the enforcement of liens. Below are the major categories of personal property liens excluded from Article 9 in whole or in part. Non-consensual liens. Article 9 generally governs only consensual liens. Thus, involuntary liens such as garage keeper liens, landlord liens, and liens in favor of suppliers of service or materials, with the exception of non-promissory agricultural liens, are beyond the scope of Article 9. All guarantees are assignable, and the mere use of "you" does not constitute a plain intent to restrict the grantor's liability to the original creditor. Champion Home Builder versus Sipes, 269 Cal RPTR 7578, 219 Cal App 3D 1415, 1422, and 1990. See UCC subsection 9-109D2. Article 9 generally provides that these involuntary promissory liens will have priority over Article 9 liens unless they are created by statute and the statute gives priority to Article 9 liens. This provision reflects the policy that liens securing work or services that enhance or preserve collateral should take priority. Article 9 generally defers to state laws regarding perfection, priority, and enforcement of involuntary liens. Personal property liens, specifically addressed by federal or state law, Article 9 does not apply to the extent it is superseded by state or federal law addressed to specific types of collateral. The primary personal property that falls into this category is titled motor vehicle, airplanes, rail cars, vessel, and intellectual property. Every state has a title law governing motor vehicles that are registered and driven over the roads in the state. These state title statutes generally require all vehicles that drive over the roads to be registered and titled, and that all liens on such vehicles be recorded, typically on the title itself. As for commercial trucks operating under ICC permits, federal law defers to the state certificate of title laws. State laws other than Article 9 can also govern perfection of liens in boats, and federal law governs rail cars and many vessels and airplanes. Copyright, trademark, and patents are also governed, at least to some extent, by federal law. These federal statutes, however, often address only perfection of liens, but not priority or enforcement, in which case Article 9 fills the gaps and applies to the extent it does not conflict with federal law. A secured party may generally enlist some. New York's Garage Keeper lien statute trumps Article 9 liens. New York Lien Law Section 184, 2007. The New York Garage Keeper must, however, be licensed within the state to invoke the statute. See NYCLS VEH and TR subsection 398B and 398C. Conversely, Arizona's and New Jersey's garage keepers lien statute expressly provides for the priority of a secured party perfected lien. ARS 33-1022B and New Jersey's A2A44-21 1998 perfected liens in title vehicle also trump impound towing and storage charges. Again, ladies and gentlemen, perfected liens against your private consumer goods. Perfected liens in title vehicle also trump impound towing and storage charges. In New Jersey, see Mid-Atlantic Bank N.A. versus Wood, 302 New Jersey Supreme Court, 286, 395, A2D 335, New Jersey Supreme Court, APP DIV 1997. Non-promissory liens, such as equitable liens, should not trump Article 9 liens. Bank Co. South Bank versus Hazelwood Logistics Center, LLC, 706 F 3D 888, the 8th Circuit, 2013. See also Chapter 4, Section S, VI and VII Infra. See UCC 9-310. See also UCC 9-333. See 49 USC subsection 14301B, 2012. Article 9 provisions such as Article 9's self-help provisions, although a federal law governs perfection questions. Airplanes. The Federal Aviation Act of 1958 governs perfections of a security interest in airplane engines and propellers, and airplanes. A secured party must file a notice of a security interest with the Federal Aviation Administration, the FAA, aircraft registry to perfect its lien. So again, it's giving you guidance if you are an aviator, you have a private consumer good that you use for recreational purposes, and it's telling you how you will properly assert your lien on your vessel or aircraft. Vessels. The federal commercial instruments and maritime lien law govern the perfection of security interest in documented vessels. A secured party needs to file a preferred ship mortgage with the National Vessel Documentation Center. A floating home, however, is not a vessel. Well, isn't that interesting? Your automobile on a highway is considered a vessel, but a floating home on a body of water is not considered a vessel. See Dietrich versus Key Bank, NA 72F 3D 1509, 11th Circuit, 1996. See also 49 USC subsection 44101 and 44113, 2012. Secured parties should consider using a specialist as an expeditor due to complexities. So basically for expedient performance, use somebody who's knowledgeable. The Federal Aviation Act only addresses perfection, not priority. Priority is governed by Article 9, except where the Cape Town Convention applies. To obtain priority in large airplanes, 8 or more people or a crew of goods in excess of 2,750 kilograms, and helicopters, 5 or more people or a crew or goods in excess of 450 kilograms, the secured party also needs to record its security interest under the Cape Town Convention by filing with the International Registry in Dublin, Ireland. Registering a security interest under the Cape Town International Registry in Dublin, Ireland, registering a security interest under the Cape Town Convention requires 2 steps. First, the secured party must obtain an authorization code from the FAA. Second, using the FFA authorization code, the secured party must register with the International Registry as provided above. See 46 USC subsection 31301 ET SEQ 2010. This includes the Shipment Mortgage Act of 1920, 46 USC subsection 31301 and 31343. The Shipment Mortgage Act addresses both perfection and priority for undocumented boats such as recreational vehicles, the secured party should perfect under Article 9. Although an undocumented boat may be titled, depending on the state, if there is a title, the secured party should record a lien on it. If the boat cannot be documented because it is too small and it is intended to be used in interstate commerce, the secured party should consider filing with the Surface Transportation Board as well. See Railroad Rolling Stock Infra. The secured party should also, in each of these cases, file a UCC-1 covering not only the boat, but also the equipment, because some equipment may not be covered by the Ship Mortgage Act. The secured party should further be familiar with the maritime liens, which can arise in favor of the repair yard, stevedores, the master and crew, as well as other providers of goods and services to the vessel. Some of these liens will be preferred maritime liens and trump even a perfected ship mortgage. See Lozman versus City of Riverview Beach, Florida, 133 SCT 735, 2013. Railroad rolling stock. The ICC Termination Act of 1995 governs the perfection of security interest in railroad cars, locomotives, and other railroad rolling stock. Perfection is effected by filing a security agreement or memorandum of the Surface Transportation Board in Washington, D.C. Intellectual property. Case law generally provides that patents, trademarks, and unregistered copyrights are governed by Article 9. Patents, trademarks, and unregistered copyrights are general intangibles. Under Article 9, perfecting a security interest in general intangibles is addressed in the perfecting of a security interest section below. But, as discussed below, the secured party usually should make a filing at a federal level as well. Copyright. Pursuant to the Copyright Act of 1976, secured parties in registered copyrights must file a security agreement or a note or a memorandum in the U.S. Copyright Office. The secured party would be wise to file an Article 9 financing statement as well. As noted above, unregistered copyrights are governed by Article 9. Trademark. The Lanham Act, like the Patent Act referenced below, generally required filing at the federal level for transfers of ownership. In the case of trademarks and secured parties should, however, file an assignment with the Commissioner of Patents and Trademark, as well as an Article 9 financing statement. See 49 U.S.C. subsection 11301 ET SEQ 1996. Note that the Railway Rolling Stock Equipment Trust are excluded from Article 9, Section 20C of the Interstate Commerce Act governs them. UCC subsection 9109 C1. See generally J. Atwood, a New York international regime for railway rolling stock assets-based financing, 40 UCC LJ 3307, winter 2008. See Moldo versus Matsko in regards to Cybernetic Service Incorporated, 252 F3D 1039 9th Circuit 2001. Patents. Trimarchi versus Together Dev Corp, 255 BR 606 D Mass 2000. Trademarks. Ericon Eng Incorporated versus Silicon Valley Bank in regards World Auxiliary Power Co. 303 F3D 1120 9th Circuit 2002. Unregistered copyrights. See also 17 USC subsection 204 205 2010 and 17 USC subsection 101. See also in regards Pershing Entitlement Ltd 116 BR 194 11 USC Rep Serve 2D 1025 CD Cal 1990. The secured party should file the security agreement or a note or memorandum of the secured interest or mortgage of copyright. 17 U.S.C. subsection 204. This note or memorandum should contain the title of the copyright work, the registration number, name and address of the secured party, and the notarized signature of the debtor. If the copyright is not registered, perfection is under Article 9 in regards World Auxiliary Power Co. 303 F3D 1120 9th Circuit in 2002. The secured party would, however, generally restrict the copyright and then file against it. See 15 U.S.C. subsection 1060 in 2002. Patents. The Patents Act, like the Lanham Act, arguably only requires filing at the federal level for transfers of ownership. In the case of patents, the secured party should, however, file a conditional assignment with the Commissioner of Patents and Trademarks, as well as an Article 9 financing statement. In summary, in the case of the undersigned copyrights, trademarks, and patents, a filed financing statement should protect the secured party from a subsequent trustee and most creditors, but federal filings are advisable except in the case of an unregistered copyright out of an abundance of caution and to protect against bona fide purchasers without knowledge of the lien. In short, if the collateral rolls over the road or rails, flies, floats, or is intellectual property, it is often not governed exclusively by Article 9 at least for lien perfection and priority issues. Rather, Article 9 governs only the extent it is not preempted. Equipment leases. Article 9 does not apply to equipment leases. These are governed by Article 2A, except to the extent the equipment leases themselves are pledged as collateral, in which case they are chattel paper under Article 9. Under Article 2A, true lease do not require lien perfection because the obligor has no ownership interest in the equipment. Equipment lease must be carefully reviewed. However, before concluding there are no lien perfection issues, if the lease is not a true lease under applicable law, but is a lease intended as security, the lien must be perfected because a lien intended as security is governed by Article 9 and not Article 2A. The enactment of Article 2A was designed primarily to address the multi-billion-dollar equipment financing leasing industry, which does not fit nearly under Article 2A. Sale of goods. Of Article 9 secured transactions, generally true leases are governed by Article 2A, and leases intended as security are governed by Article 9 for perfection, default, and remedies, and Article 2 for warranties. UCC subsection 1-201-37, which was amended simultaneously with the enactment of the Article 2A, has eliminated most of the various disputes and inconsistencies surrounding the true lease issue. Section 1-207-37 is often referred to as a bright lines test. The bright line test introduces a two-step test to determine whether an equipment lease is a true lease or a lease intended as security. The test is disjunctive. A lease must satisfy one of the two requirements to be deemed a true lease. The first prong of the test considers whether the lease may terminate the payment obligations under the lease before termination of the lease. Most three-party equipment finance leases will not satisfy this requirement since they provide for unconditional, non-terminable obligations and indeed often contain hell or high water provisions precisely to eliminate the leasee's rights of termination. The second prong of the test pertains to the residual interest under the transaction, and it is an economic test that generally provides that if the lessor retains a meaningful value in the leased equipment at the end of the lease terms, the transaction is a true lease. In contrast, if the lessor does not retain a meaningful interest, such as when the lease can acquire the collateral for $1 of other nominal sum or other nominal sums, or when the leased equipment will have little or no value at the end of the term, the transactions will not be deemed a true lease. In determining whether the transactional documents constitute a true equipment lease or a lease intended as security, courts generally will not rely upon how the parties styled the documents, since the intent of the parties is not relevant, but will instead examine the economics of the transaction. In a nutshell, if the obligor is acquiring equity in the collateral over the course of the transaction, the court will generally regard the transaction as a lease intended as security and not a true lease. In contrast, if the obligor is not acquiring equity over the life of the transaction, the court will generally view the transaction as a true lease. The most significant factor weighed by court in determining whether a transaction is a true lease or a lease intended as a security is whether there is a nominal option or other side agreement providing the leasee with the right to acquire the collateral at the conclusive of the term for less than fair market value. But courts may find that a transaction is not a true lease even when the collateral's economic life substantially exceeds the terms of the lease and the leasee does not have a nominal purchase option. In the economic realities are such that the lessor is highly unlikely to seek turnover of the collateral at the conclusion of the lease terms. This economic realities test has become quite popular in recent years, an option which is really a put or an obligation of the leasee to buy the leased equipment at the end of the lease, with the leasee obligated to pay any shortfall in the base price and to keep any surplus will often be held to be a lease intended as a security under sections 1-201-37. The courts may examine other factors, including whether the collateral has any meaningful value at the conclusion of the lease terms, whether the lease terms exhaust the useful life of the collateral, and whether the leasee can exercise a nominal extension of the lease for the economic life of the collateral. Terminal Rental Adjustment Clause, TRAC, leases are hybrid transactions that can be very challenging to classify, especially since they can often be viewed as a put, P-U-T. Fortunately for TRAC lessors, leasors, many states have passed TRAC legislation. Courts are split, however, on interpreting this legislation. Some courts take the view that the legislation requires TRAC leasees to be deemed true leases, while others take the position that TRAC statutes only prohibit TRAC leasees from being automatically deemed non-true leases, but still require a court to conduct the full true lease analysis. Tip: it is often difficult to determine with certainty whether a transaction will be deemed a true lease. Accordingly, it is advisable that the practitioner, out of an abundance of caution, comply with Article 9. Article 9 expressly provides that filing a UCC-1 is not an admission that a transaction is secured. Miscellaneous exempt personal property. Additional specific personal property excluded from Article 9 includes wages and assignments of claim for wages, salary, or other compensation of any employee. That's UCC subsection 9-109 D3. Note: this exclusion is limited to wages or other employee compensation. Thus, an independent contractor may create an Article 9 security interest for monies due to the independent contractor. Sale of a business. A sale of accounts, chattel paper, payment, intangibles, or promissory note as part of a sale of the business out of which they arose. UCC subsection 9-109 D4. Assignment for collection only. An assignment of accounts, chattel paper, payment intangibles, or promissory notes that is for the purpose of collection only. UCC subsection 9-109 D5. Performing party and assignments of a right to payment under a contract to an assignee that is also obligated to perform under the contract, UCC subsection 9-109 D6. Limited assignments and satisfaction of debts. An assignment for a single account payment intangible or promissory note to assignee in full or partial satisfaction of a pre-existing indebtedness you will find under UCC subsection 9-109 D7. Insurance policy claims other than health care receivables, a transfer of an interest in or an assignment of a claim under a policy of insurance other than an assignment by or to a healthcare provider of a healthcare insurance receivable, and any subsequent assignment of the right to payment you will find under UCC subsection 9-109 D8, UCC subsection 9-315, and subsection 9-322 may apply to any insurance as proceeds and priorities in proceeds of other collateral. A tip: generally under non-Article 9 law, the secured party must provide an insurance company with an assignment of insurance. Consult the insurance company for its approved forms. Some states may also require that the secured party take possession of the policy to perfect a security interest. It is advisable that a loan documents included a provision that the secured party may use the insurance monies to pay down the debt even if the debtor is not in default at the time. Also, a secured party may be added to the insurance as a loss payee. If the secured party is not named as a loss payee, it should comply with UCC subsection 9-315 and 9-322 to ensure perfection in proceeds in the hands of a debtor. Some states and some insurance policies have notice requirements. It is a best practice for the secured party to send a notice of assignment, judgments and assignments of a right represented by a judgment unless the judgment was taken on right to payment that was collateral. Such an account, UCC subsection 9-109 D9. Tip: generally under the common law, the secured party should obtain a written assignment, file it with the court, and, if possible, notify the judgment debtors. Recoupment of set-off rights. A right of a recoupment or set-off except UCC subsection 9340 applies with respect to the effectiveness of a right of recoupment or set-off against deposit accounts, and UCC subsection 9404 applies with respect to defense or claims of an account debtor. UCC subsection 9-109 D10A and B, interest in real property. The creation or transfer of an interest in a lien on real property, including a lease or rents thereunder, except to the extent that provision is made. Liens on real property in UCC subsection 9203, automatic attachment in supporting obligations such as an LLC or guarantee, and in supporting liens such as a mortgage, and subsection 9308D, automatic perfection. Two important concepts must be noted in connection with promissory notes and mortgages. First, the mortgage follows the note. Ladies and gentlemen, if the bank takes your mortgage and converts your promissory note into an order to pay and separates the mortgage from the promissory note, they are a nullity. First, the mortgage follows the note. Second, because the mortgage follows the note, Article 9 trumps real estate mortgage laws regarding priority of liens in mortgages. Thus, where a note and mortgage were double pledged, creditor A perfected under Article 9 by taking possession of the original note and filing a UCC 1, and creditor B perfected by filing a notice of the assignment of the mortgage in real property records. Creditor A had priority in the note and mortgage. Accordingly, when taking a lien in a note and mortgage, perfection under Article 9 is paramount, even though the mortgage clearly is an interest in real property. Fixtures in UCC subsection 9, 334. Fixtures filing in UCC subsection 9501, 9502, 9516, and 9519, and security agreements covering personal and real property in UCC subsection 9604, 9109, D11A through D. Non-commercial tort claims and assignments of the claim arising in tort other than a commercial tort claim, except that UCC subsection 9315 and 9322 apply with respect to proceeds and priorities in proceeds. UCC subsection 9109D12. When a tort claim settles and becomes a contractual obligation, it is covered by Article 9 as a payment intangible. You will find that in UCC subsection 910261. Consumer deposit accounts. An assignment of a deposit account in a consumer transaction, but UCC subsection 9315 and 9322 apply with respect to proceeds, priorities in proceeds. UCC subsection 9109D13. Article 9 does not preclude security interest in consumer deposit accounts, but this area is governed by the common law. Remember how I told you guys that the common law and the UCC had to be in harmony, or the UCC was rendered null and void? Well, here's where you're going to get to see where they're in harmony with one another, as are the statutes for the state. Although generally passed by legislation, some of these statutes are in fact found to be in conflict with common law. But again, the basic premises for law is common law, God's law, natural law, and thus the creation of law. Generally, under the applicable common law, the secured party should have the debtor assign the account in a written security agreement. The debtor should not have any control or access, and there should be no notice to the bank. The bank should also agree that it will not remit any funds to the debtor without the secured party consent, that it will remit the funds to the secured party upon default and request, and that subordinates any security interest or set-off right it has or may have. State as debtor. Security interests granted by a state or state agency are governed by Article 9 in the absence of the statute providing otherwise. Many states have, however, adopted non-uniform provisions of Article 9 which exclude security interests granted by state or states agencies from Article 9 UCC subsection 9-109A1. This exemption should be limited to transactions where the state is the debtor, and Article 9 should still apply where the state is the secured party. Non-code legislation. Under UCC subsection 9201B, a state can identify all statutes that continue. I'm about to lose power, ladies and gentlemen. Let me see if I can get through this before it dies. A state can identify all statutes that continue to apply to Article 9 transactions, although Article 9 appears to, or purport to, supersede such statutes. The statutes specified typically apply to small loan accounts, retail and motor vehicle installment accounts, and consumer issues, and are not repealed by Article 9, of course. Federal legislation, like the Truth in Lending Act, Regulations M and Z, and the Fair Debt Collection Act, 15 U.S.C. subsection 1692 E.T. SEQ also apply alongside Article 9. Additionally, unless specifically precluded by Article 9, general principles of law and equity still apply, including fraud, misrepresentation, and unconscionability. Key terminology. Secured party means a person in whose favor a security interest is created or provided for under the security agreement, whether or not any obligation to be secured is outstanding. B. A person that holds an agricultural lien. A. Cosigner. A person to which accounts, chattel paper, payment, intangibles, or promissory notes have been sold. A trustee, indenture trustee, agent, collateral agent, or other representative in whose favor a security interest or agricultural lien is created or provided for. Or F, a person that holds a security interest arising under UCC subsection 2, 401, 2, 505, 2, 711.3, 2A, 5085, 410, 4-210, or 5-118. Debtor means a person having an interest other than a security interest or other lien in the collateral, whether or not the person is an obligor, a seller of accounts, chattel paper, payment intangibles, or promissory notes, or consignee. Obligor means a person that with respect to an obligation secured by a security interest in or an agricultural lien on the collateral, owes payment or other performance of the obligation, has provided property other than the collateral to secured payment or other performance of the obligation, or is otherwise accountable in whole or in part for payment or other performance of the obligation. The term does not include issuer or nominated person under the letter of credit. Secondary obligor means an obligor to the extent that the obligor's obligation is secondary, or the obligor has a right of recourse with respect to an obligation secured by collateral assignment, secured by collateral against the debtor, another obligor or property of either. Account debtor means a person obligated on the account, chattel paper, or general intangible. The term does not include personal obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. Collateral means the property subject to a security interest or agricultural lien. The term includes proceeds to which a security interest attaches, accounts, chattel paper, payment intangibles, and promissory notes that have been sold, and goods that are subject of a consignment. Security agreement means an agreement that creates or provides for a security interest. Financing statement means a record or records consisting of an initial financing statement and any filed record relating to the initial financing statement. Authenticate means to sign or to execute or otherwise adopt a symbol or encrypt a similarly process a record in whole or in part with the present intent of the authenticating person to identify the person and adopt or accept a record. So again, it's to adopt or accept a record. Communication means to send a written or other tangible record, to transmit a record by any means agreed upon by the person sending and receiving the record, or in the case of transmission of a record to or by a filing office, to transmit a record by any means prescribed by filing office rules. Practice tip: incorporate the definition of communicate into standard loan documents. Avoid sending foreclosure notices electronically, especially in the consumer cases. Although this process is approved in the 2010 amendments to Article 9, the 2010 amendments, under Article 9, the debtor and obligor are not necessarily the same person. This distinction can affect issues of attachment, default, and foreclosure. The definition of authenticate and communicate provide for the electronic acceptance or acknowledgement of a record in lieu of a personal signature for the electronic transmission of a communication. Important basic concepts. General, good faith. The UCC requires honesty in fact and the observance of reasonable commercial standards of fair dealing. This requirement applies to Article 9. Okay, so let's just talk a little bit about in good faith. When you're acting in the color of law, you couldn't possibly be believed to be acting in good faith. And again, good faith emulates common law, where common sense dictates natural law, God's law. So when we're doing something in good faith, that's important to remember that. So to Article 9 transactions, and appears through the UCC generously. B, official comments. The official comments to Article 9 do not have the probate value of legislative history. Lost them.